I mean, the guidelines that we have provided to the officers to assist them in considering the Minister's comments, I mean, that's an approach that we've recommended because there is no direct case law saying exactly what they have to do. And I mean, I'm sure there is scope to say that, I'm sure someone else might argue have particular regard to means something slightly different. But this is, we've taken guidance from accepted case law. In terms of the decision makers, when they make their decision, they have to have particular regard to criteria as well. So yeah, so that when they may well, yeah.
And I think that it would be right to put on record the alternative to this process, because we asked the ministers to provide us with a fast-track process in order to deliver a district plan review. The alternative would have been to simply hand the whole process over to the government for them to do a plan and call for public submissions and resolve it. I'm very comfortable with the fact that we maintain a degree of, well, we retain control over what is publicly notified, and I think that that is a much better position for us to be adopting as a council than to hand the whole process over to central government. All right, so with that, the community board council workshop is being set up. It may have to be a Saturday, people, I'm sorry, but community boards find it very difficult with work obligations to make themselves available during working days quite often. Right, so we'll move on from there. The particular areas that we have some interest in, and I think rather than just going through clause by clause, which we may have to do to kind of wrap things up, but recognising the amount of time that we have, colleagues have raised particular issues around intensification, urban design, accessibility, sustainability and notification. There's also been an issue raised around the designations that the Minister asked for response to, and I have to say that it's, I mean, you've done a fantastic job in putting this all together, but it is a complex set of documents, and it is hard to follow, one to the other. They're not all cross-referenced in an easy way.
Would it be helpful for me to give you a very brief overview of the reports, and particularly the attachments and what they are and how they relate or don't relate?
Yeah, that would be good.
Okay. Well, I think the report itself is fairly self-explanatory, and where perhaps the difficulties come in is the amount of information and the 6 attachments that there are. So the first attachment is actually a copy of the Minister's comments for you all to consider. And those Minister's comments have been around the Statement of Expectations for the most part, including the Natural Hazards chapter. So the statement, the areas that they've made comments under and recommendations are, for example, strategic outcomes, balancing flexibility with certainty, residential land supply and encouraging intensification, temporary activities, business development, capacity, recovery and growth, natural hazards and clarity and ease of use. And under those headings there are things like, under strategic outcomes, the request for bespoke policies for recovery and rebuilding in the replacement plan, how proposals work together to produce desired outcomes, provide clearer direction of what needs to occur to facilitate a vibrant and prosperous district, and in particular for Christchurch. And under balancing flexibility and certainty, for example, there are issues of the Minister's not considering that we have reduced significantly the numbers of standards, assessment criteria, urban design standards, that kind of thing. They're wanting to see the life mark and homestar provisions deleted. And there needs to be more reduction in consenting and notification requirements, for example. Under land supply for residential business, they're suggesting that there isn't enough intensification both around the KAC and just in general. Also not enough land for business activities. Under temporary activities, they've recommended that we allow for these in stage 1, not in stage 2, in acknowledgement of the businesses that actually have relocated to these areas to have some certainty through to 2016, well before 2016 when the rest of the chapters go through. And for example, under natural hazards, they have allowed us to include the additional maps that we've talked to you about before, the prohibited areas, and they have requested that we also include the recent mass movement maps that we've received from GNS, so that's helpful. And some issues around terminology needs definition, that kind of thing. So what we've done in the comments, and this is very broad brush, a general statement, is if I had to give you a general idea of what there is in those comments, I would say that roughly about half of this we have recommended with quite substantial reasons that there be no changes. And of the other half, we have recommended about 2/3 of the other half would be small amendments where officers have taken the opportunity and responded well to making changes to clarify and further improve the wording. And then there are new additions or changes as well. I've already talked about the two types of maps, but for instance, there's a new definition for hazard mitigation. There are 2 advice notes going in regarding natural hazards, what's in stage 1 and what's in stage 2 chapters. We have provided a full new set of rules for temporary activities, and there is a reduction in notification in the commercial chapter. And that's what we'd go through with you. Also under no changes, for example, we have there was a comment to extinguish existing use rights. Well, of course, we can't do that under the Resource Management Act, Section 10. They have asked to put in more about the Christchurch transport strategy, but we feel there isn't a need because, of course, the district plan has to give effect to, and in places with the recovery strategy not be inconsistent with those higher order documents, so there isn't a need to repeat them, for example. We simply need to give effect to them. For example, we have said no to deleting, or suggested no to deleting urban design rules and the Homestar and Lifemark provisions. But as you've already indicated, Mayor, we will go through those with you, perhaps as a priority first off. Yep. Just looking at the report itself, I'd just like to tell you what's in each of the attachments for your edification.
But do page numbers for us.
Oh, right.
Yeah.
Okay.
Appendix 1, the attachment 1, page 38. This is their statement of expectations.
No, we're just going to go through the whole report to say what's in it.
Yes, it is. Okay, so the first attachment is the Minister's comments. And you're quite right. The last page of that, Appendix 1, is the statement of expectations that was inserted into the OIC. And they can almost be read like, correct me if I'm wrong, not being a lawyer, they can be read like further principles that must be given effect to in considering the district plan.
Just
or not
so
given
that we
effect
can
to,
consider
have particular
that,
regard to.
have we got our statement of expectations? Because I haven't bought all the documents that you previously gave us.
It should
No.
It's in your...
strategic directions
Okay,
chapter, isn't it?
Okay, fine.
Yes.
Because we don't have a statement of expectation. That we have the strategic directions
That's
chapter.
correct. That's correct.
Did you want the chapter? It's here.
We have put on your desks hard copies of the chapters as they went to the ministers, but what we wanted to do for you today is actually show you ePlan live, and we'll bring it up on screen when you want to flick to any of the chapters or the maps.
Can I just ask the statement of expectations, or what's the other thing called? The big overriding.
The strategic directions
strategic
chapter.
Directions, which has priority?
It's not a matter of priority. The strategic directions, as all of the chapters in the district plan, need to have particular regard to the statement of expectations.
So in terms of the hierarchy of what's being written, is the statement of expectations the prime thing in the hierarchy?
No, they have to have regard. You have to. all of the chapters of our district plan have to have regard to the statement of expectations.
I just want to get the legal sense of it. So if the commissioners are sitting, the overriding first thing that they're going to have sitting here listening to the submitters is the statement of expectations?
No, so they will have it sitting there, but under the RMA you have a number of relevant documents, other plans, and there's basically a hierarchy of them. For the council's review, we have an additional document, which is the statement of expectations, and the council, as it prepares its proposals, it has to have particular regard to them, and the decision maker also has to have particular regard. That sits in at the same level of the other documents that the council and the decision maker have to consider when they make decisions through this process. So it's not at the top of the hierarchy, no, but the strategic directions that you mentioned, that is a chapter, that is a proposal in the proposed plan that will be notified.
So this statement of expectations that's on page 38,
yes.
Are we allowed in any way to interfere with it?
No.
You can't interfere with it, but remember what it is. It is the expectations of the Minister for Canterbury Earthquake Recovery and the Minister for the Environment that the replacement district plan will X, Y and Z. So it is their expectations, and we as a council have to have particular regard to it, and the decision makers have to have particular regard to it as the expectations of those two ministers.
Yes.
In some instances, they don't meet the expectations of our community. We are perfectly entitled to speak on behalf of our community and notify that. The decision makers are also entitled to listen to the submissions and make their own judgment, having particular regard to what the two ministers want.
Okay, and if a submitter makes this statement, but it's not aligned to the statement of expectations, I'm assuming the statement of expectations has the higher ranking.
No, we have to have particular regard to it, and so does the decision maker. The words particular regard, we heard right at the very start that we're in new territory and that there aren't, sort of legal precedents that we can call upon to say what the issues, how the issues would be determined in a court. But remember, this doesn't go by way of appeal, only on a point of law. So if a point of law were to call upon that, the court would be looking at the fact that these are the expectations of two ministers for the replacement district plan. They are simply that, and decision makers have to have particular regard to them. They don't have to override anything.
Absolutely, and can I just add, when the panel makes decisions on these proposals, it has to comply with the RMA, and in the same way that any other decision maker considering proposals on a review has to.
So we've already heard, for example, that the ministers have asked for something we can't legally give them. Yes, David.
Could we just have a little bit more of a definition with respect to this particular regard and how that applies to our obligations, the minister's obligations, the RMA? Where does this particular regard, how do you define it a little better?
That's just what you've already said. It's that part.
Okay. Yeah. So in the perhaps if I outline, the Ordering Council has a clause that sets out the relevant considerations when making a decision. There are a number of things that a decision maker must do, and the decision maker, one of those is to have particular regard to the statement of expectations, but also the decision maker has to undertake and have particular regard to a further evaluation of the proposal, which is what we call the Section 32 evaluation. It's something that we brought to you in June. The reports were brought to you in June. They have to apply sections the relevant sections of the RMA, which outline what you have to do when you're preparing a plan. Things like having regard to, giving effect to the regional policy statement, any other higher order documents, management plans and strategies prepared under other acts. What else have we got in here?
They have to have regard to the council's evaluation reports, any notice or information about a requirement, and any other information that the council considers to be relevant. And as soon as is reasonably practicable, after the council receives any submissions on the proposals, the council must provide them to the hearings panel. So all of these things go into the mix, but they have to have particular regard to the statement of expectations.
May I suggest, Madam Chair, it also might become more clear when we go through each of the aspects, particularly the priority aspects that you've already mentioned, and we go through our reasonings for our draft recommendations, it will become clear how that matter has been weighed.
So we have to have particular regard to it as well, but we are having regard to other matters which we're perfectly entitled to do. Glenn.
Thank you. I'm curious with this. We've been asked in recommendation 20 ourselves to be clear and legally robust in our terminology and definitions. So I'm curious about what is, in that phrase, terminology, particular regard, how legally robust itself is that?
It's becoming a bit difficult for us to mix the general with each specific recommendation or comment. So perhaps,
I think as we go through it, it will come clear.
Yes.
I mean, at each stage, we will have particular regard to the Order in Council, and we'll see how that works in practice. So I'm mindful of the fact that morning tea's going to be outside in 5 minutes. So why don't we choose one of the...
well, Madam Chair, would you like me to just continue just at least with, outlining
yes, you were going to
attachments?
Sorry, I apologise.
So that when we make comments, we can sort of flick between them if we need to, and you'll know what we're talking about.
Yeah.
So on page 39, then, is attachment 2. Page 39, that chart there, which goes on for some pages, was developed and given to the ministers during their 15 working days for them to consider whether or not they would allow us to make these changes through them putting them in their written comments. So this occurred after we took the chapters to you, where we've noticed there are some when I say more significant, they're definitely not minor changes, so we have asked them to seek us to change our plans on the basis of these comments in this table, Table A. And for example, what's in there is a request to the ministers to seek any comments back to us that we include the new mass movement chapters, the new mass movement maps from GNS, for example, which they have put in their written comments. Now, there are only two parts of this table that they have included in their written comments, and it's exactly that. It's about the maps, and it's about allowing us to change our activity status of Cliff Hazard Management Area 1 to prohibited. So this table then gives an indication of what officers would like to seek through a submission to our own plan to amend things along the lines of what we've already discussed, but there are some amendments that need to be made. So then we move on to attachment 3, which starts at page 83. This is another table that was also given to the ministers during the time of their 15 working days to consider the chapters. Now, this table here was also written by officers. The issues aren't as significant as in Table A, but we gave it to the ministers for them to consider whether they would wish the council to make these changes prior to notification. And again, it's where officers have picked up mistakes or amendments that are needed to make clear the purpose of the wording. in my understanding, nothing of this table came through in the Minister's comments. So again, that's what we would seek to go on to achieve through a submission to our own plan. And
just let me clarify that. That is because we cannot make changes that weren't in the areas specifically notified by the ministers at this stage.
That's correct. They weren't included in the drafts that went to the ministers.
Yep.
We picked them up after that process.
Yep.
So then attachment 4 is the last table, and it starts on page 103. Now this is the third of the tables that officers developed and gave to the ministers during their 15 working days. This really is just minor corrections, just to clear up errors, mistakes, spelling mistakes, that kind of thing. Now that is within this committee's gambit to allow us to make these minor changes before it goes to notification. So you'll see one of the recommendations in the report is simply to approve that we can make these changes as per attachment 4 to
because
the chapters
they're minor
before
and
it goes
technical.
out. That's correct. Now, attachment 5 is the big one, and that starts on page 123, and that's what we're really focused on here today. Attachment 5 goes through not only the 29 recommendations that came through from the minister's comments, but also the supporting paragraphs, 107 of them. So that's why that's such a big table. And then attached to that table, within that attachment, there is also an appendix where some of the amendments that we have put through in draft recommendations, like, for instance, temporary activities, it's a whole set of new rules, are actually in the appendix to that attachment because they're too big to put in the chart. I understand it's a very long, confusing document, but that's why I'm trying to clarify it for you. And the very last attachment, which starts on 263, is the rollover designations from all other requiring authorities except council's own designations, which will come through in stage 2 of this process. Now, the designations didn't need to come to you before they went to the minister. They are allowed, this process is allowed under the Resource Management Act, and we were required to put these designations, all except CCCs, into the first stage. So that's really a process matter as such. So that might help you to understand when we're flicking through the different tables what their relationship is, but primarily we'll be focusing on attachment 5.
Can I just start with the designations thing, because we'll clear that up. If we go back to the minister's comments, I think it is.
Yes,
so
the first attachment.
Page 28. So page 28 talks about, I mean, obviously the Justice and Emergency Services Precinct's just a typing error. And stadium. I couldn't find where that's, where is that dealt with?
Adele? I do have my whole team here of authors of the various chapters, so I will be referring to them for detail.
Yeah.
This is Adele Redburn.
And this is the frame as well, because I just don't recall us being in the Central City Recovery Plan area at all, and these seem to have come through.
Yes.
So I've kind of overlooked them.
Yeah, I can answer that one. So the OIC requirements in terms of designations mean that all designations in the district where a requiring authority other than the council wants to roll over a designation with or without modification, that has to happen through phase 1. So that is including the Central City designations,
right.
So the minister's designations. So that's why you'll see them there.
So they're in this last chapter, the Sarah designations. I don't know. I'm just looking for it.
Is it possible?
263.
But there's actually no list. So is it possible to actually get a map of what these designations are and
Yes,
a list?
we can show you.
That would be
they're on
great.
the map somewhere.
Thank you.
We can actually show you, Councillor, on e-plan right now, if you like, what they look like on the maps.
Yep. Okay, pull that up. But 263 isn't the Sarah one.
Do you know which
Sarah's.
maps?
It used to be 39, but whether it's changed.
276, is it? No. Where's the Sarah one? Is it 263?
Move it over.
Oh, right.
And point them out. There are printed copies over here, but we just wanted to show you it on the screen as well.
They're exactly the same as in the operative city plan as well. They've been rolled over without modification.
But didn't they get upset about a change of name?
Yes, so they've highlighted to us a typo and that we'd incorrectly recorded the notation, which actually isn't a formal requirement for a designation, but we've corrected those, and also a formatting irregularity, so we've corrected those.
It was just the east and north frame.
So
That was the one.
Yeah, they were joined together rather
Yep.
than being, they were separated rather than joined together, so they had been put back together. It's a formatting issue.
Can I just clarify then, the only way that these designations can come off is via the minister that's put them on? For example, in the Minister of Earthquake Recovery ones.
So we're obliged to include the requirements into the proposed plan for notification as they have been requested by the requiring authority.
Yep.
So we must do that, and any changes to those requirements would, if any, come through the submissions process and the decision process
but
from the
just-
hearings panel.
Just in terms of, once that's in the district plan, the only way that those designations, for example, in the central city, could come off would be if the minister who designated them took off the designation.
That's correct.
Right. And can I just ask about the 116 Ministry of Education designations? Are there any surprises there that aren't existing schools? Or
There are no
education
new
specific?
notices of requirement for the schools. They've all been rolled over with mostly minor modifications.
Oh, thank you.
So what page is this on? Sorry,
263.
which map?
Oh,
Do you know what number of map this is? Does it say?
39. 39.
Just on the schools, though, there are 3 new schools that are that notice of requirements have been lodged by the Minister of Education, but not through the district plan process, not through they've been handled separately through under section.
Can you tell us what they are?
I believe that's Milnes Road and Horswell.
It's been there a long time. They bought that land a long time
They
ago.
bought the land, but it hasn't been designated for
Okay,
school purposes.
yep.
And Horswell West, that's in the Night Stream Park subdivision.
Okay. A whole school?
And new school, new primary school.
New primary school.
And Preston's.
These had blanks covered by the...
Is there anything with the school ones that where there's schools that are scheduled to close have had their designations removed or changed?
My understanding is that so they've all been rolled over, even the schools that have been proposed for closure, they've been rolled over. The only change being that they've annotated the heading as closed. And I understand the basis for that is that they hadn't finished making the decisions, so they weren't in a position to be changing those requirements at this stage.
But for the ones that have closed and have had decisions, why would you still have a designation on that?
Because there's a process of buyback through Ngāi Tahu.
Yeah, they haven't made any decisions on those.
Right, okay.
Can I just ask, the Knightsbridge one is a primary school?
Yes.
Milnes Road Primary School?
Yes, I believe so.
And Preston's?
I think it's a primary as well, but I'm not sure. I haven't had any involvement in it.
What?
Okay.
Is it? Okay.
Yes, it is.
And the central city ones where designations have been removed, are they rolled over as well? Or?
There's no removal of designations.
But I thought, my understanding was that the minister's removed some designations around like performing arts precinct, around...
He's lifted the designation on the north part of the previous performing arts precinct.
Yes. So in terms of schools, it's the Minister of Education designations, and there's been no removals. And the designations for the Minister of Canterbury Earthquake Recovery have all been rolled over without modification, but there have been deletions made to those designations under a separate process to the operative plan. So under section 182 of the RMA, any minister or the requiring authority can delete designations to the operative plan, and he's done that and then rolled them over into the proposed plan, unmodified.
So we have no say in the minister's designations?
No.
Is that because of the order in like, is that or is that just normal throughout New Zealand?
That's a usual process.
Okay.
So if the council wish to make any comment on a requiring authority's designations or notice of requirement, it would be through the submissions process.
And normally it would be that the hearings panel will make the final call about those designations, is that correct?
Under the RMA, the requiring authority themselves would make the decision. There's a slight difference under the OIC where, Sarah's probably more in favour with this, but where the hearings panel will make the ultimate decision rather than the requiring authority.
Just to clarify that, what the panel does is it makes a draft decision and report, and the council has to make that draft report public. Certain people have, including the council, the requiring authority, and people who have submitted on that designation have an opportunity to comment on that draft report and decision. Those comments get fed back to the panel, and then they make a final decision.
Okay. Can I just ask one last question on that? On all those ministerial designations, or Telecom or Orion or Kiwi, is there anything in there that would take us by surprise that we're not likely to know about?
Most of them have been rolled over either without modification or just minor boundary adjustments and so forth. The main exception probably is with the Christchurch International Airport Limited's Christchurch Airport designation, where they have sought to extend the boundary by 216 hectares. So that's probably the largest change.
So do you have that, so that takes it into some other areas that are
No, it's still contentious in our district plan review, does it?
It's around the airport. It's just an
Is it
extension of the boundary.
The noise boundary?
It's partly that. It's farmland all around it that the airport are seeking to provide additional protection.
Does it come further back down Memorial Ave by any chance?
It's around different parts of it, on all sides really. But there is a small amount that crosses Russley Road for the Reaper, what are they called? Runway end protection area. There's a little bit across across Russley Road.
Does that have any major impact on any of the land developments surrounding the airport that have been discussed here?
Oh, I don't know. I'm not in a position to advise on that.
Okay.
At this point, we're required to put all the designations into the proposed plan, and there'll be a separate process for determining whether or not, what the implications might be for council and receiving your feedback on those.
If we as a council wanted to put designations on, can we do that? And
we will, and that will be part of stage 2. That's what I said. These are all other requiring authorities.
Is there nothing like, I'm just thinking of things like cycle, is there nothing we would do now that we would want the designation on?
We can't notify now because we haven't had any public process ourselves.
No, these didn't go through any public process.
Yes, but they're existing designations that have been confirmed by existing requiring authorities.
For some time, they're being rolled
They've been
over.
through a process
So
already.
what's the process for us to put designations in place?
Stage 2 is what I just heard.
Yes.
So if we want to put forward designations as part of our plan, we need to do that in stage 2.
That's correct.
Yeah, but
and we haven't got the information yet for our council designations.
But in terms of like, we'd identify a site, we'd then go out to the community and say, this is what we're doing. People would make submissions, then we would come and put it in, or we just do it in a more generic sense?
No, because these are operative designations that are already in the plan. All those people affected by them know about them, and this is a process that gets rolled out in plan reviews throughout New Zealand. The requiring authority get an opportunity to bring them over, but they do get an opportunity to modify them. That's often to update, depending on the works that they've been doing, basically to keep them up to date. They can withdraw them if they think they're not needed anymore, but the council's role in this is that it has to include them in its proposed plan. They're already in the operative plan. Yeah, so in terms of the new one, do you want to speak to the new one, or do you want me to?
Just before we go on to that though, could I ask Alan to make a comment? There was a question about the extension of the airport designation and does it have an effect on land that's not owned by the airport. One of the reapers, can you use the pointer?
So if you look on the
map
up there, you just see I'll just move it on to the site. So this is the mail site that we've spoken about before, and you'll see just on this corner here, part of the mail site there, and the extension of the designation going down to here. So this is one of the minor extensions to the airport. You will see we're aware of potential developments for that mail site area, and they are also aware of the designation and have taken that into account in terms of layout of activities and so on that mail site. So they are aware of that airport extension. Yeah.
Can we? Yeah.
There is some additional land that's not council owned. Unfortunately, I haven't got the map here.
Is it in the Eastern?
Has that got chapter 10 in it?
No, it doesn't.
I can provide you with a map that the actual notice of requirement, the rollover notice, shows the land that's proposed to be extended and what proportion of that land is owned by the airport and which is third-party land. And it's not just the land that is associated with the reaper. There's also some land, some farmland to the west of the airport that the airport is looking to designate to protect airport operations from things like bird strike risk.
Paul?
Just on that mail site, that extension of the designated land from the airport, that's a new change, and that has been accepted and it has gone through? No. So it's actually proposed?
That's right.
That's right. So the hearings panel will make a decision on that. Those people who own land, so they will be receiving, as well as the general public notice of the proposed plan, they will be getting a letter saying there is this designation in the proposed plan, and directing them to the relevant information to look at it. And then they will also have the opportunity to submit on the designation and make a further submission.
If this goes through, I just want to get an understanding of how that would affect the land use.
I'll just bring Glenda forward. Glenda's been doing a lot of work on reapers. Sit down here. Runway and protection areas. There was a previous...
This sounds very grim to me.
There was a previous plan change put forward by the airport as a private plan change, and that was heard in, I think, 2010. And that was to extend these reapers, runway and protection areas on the cross runway at both ends. The bit that we're seeing now is being proposed to be added to the designation as an amendment to the designation was the bit that the Commissioner at that time recommended not be included in Plan Change 16 because it was private land, and he thought that that process of imposing a land use control on that land was onerous. That's because the actual land use controls in those small areas are very restrictive. That's an obstacle protection surface. So it basically means that no new structures can be built in that area, not even, a little shed. So it's very onerous. And he decided at that stage that he didn't think that was appropriate for those pieces of land to be, or that bit there, to be included as just a straight land use control. He thought it ought to be designated, and that's actually what the airport is now proposing. That gives people a right to take that to submit against it to hearings panel.
The only other designation that was included in the letter was the health one in relation to the acute services building at Christchurch Hospital. So have you resolved that one?
Adele?
Yes, so the Minister of Health designation for the acute services building was included into the operative city plan under the SARE Act, so not under the usual RMA process. So we had an operative Minister of Health designation that came into the plan after we had asked requiring authorities whether they wanted to roll over their designations. So we subsequently wrote to the Minister of Health once the OIC was gazetted and asked them if they wanted to roll over their designation, which they have done, and with a minor modification, and so we've now included that into the proposed plan as well.
All right. So, yep.
Does this include the part of the hospital in terms of Hagley Park that takes over Hagley Park?
I haven't got the actual map out.
We can come back to you on that.
Is it possible just to get a map and just understand really clearly what?
It's not on there because this is the one that went to the ministers.
Oh, okay. It's not on this map because these maps are the ones that went to the ministers and the designations weren't included on that. We can give you a copy of that though. We can bring that back.
Yep. All right. So I think we're going to drop. I think we're going to break for morning tea and be back here at 11 o'clock. Thanks.